The Fifth Circuit Court of Appeals has officially withdrawn its controversial decision that declared suppressors are not arms and therefore not protected under the Second Amendment. This major development comes after a shift in legal stance by the Department of Justice under the Trump administration, which now argues that suppressors are indeed protected arms and cannot be outright banned. We've just received confirmation that the Fifth Circuit has mooted the previous petition, effectively nullifying the prior ruling. This is a significant move, especially in the context of ongoing legal battles surrounding the constitutionality of suppressor regulations under the National Firearms Act, NFA. In today's video, we're going to break down the suppressor case that has stirred serious debate across the gun rights community. This is the case of United States v. Peterson, which challenged whether the NFA's suppressor restrictions violate the Second Amendment. Mr. Peterson was originally convicted for violating the NFA over the possession of a suppressor. He argued that the NFA's provisions infringed on his constitutional right to keep and bear arms. Initially, a three-judge panel from the Fifth Circuit ruled against him, stating that suppressors are not classified as arms under the Second Amendment and therefore not entitled to constitutional protection. However, a major shift occurred when the Trump DOJ, through a filing led by Pam Bondi, took a new position in front of the same court. The DOJ stated that suppressors are considered arms and cannot be banned outright by either the federal or state governments. That said, the DOJ still maintained that the NFA's regulatory scheme does not constitute a complete ban and thus doesn't violate the Second Amendment in its current form. The DOJ's change in stance triggered significant reconsideration. In response, the same three-judge panel from the Fifth Circuit has now withdrawn its previous opinion in the Peterson case. This likely signals that the panel intends to rehear the case and issue a new opinion regarding the legal status of suppressors and the constitutionality of the NFA. Additionally, the Fifth Circuit has now declared the petition for an en banc rehearing, where the full court would review the panel's decision, to be moot. That means the case will now move forward solely before the original three-judge panel without a full court review at this stage. Following the original ruling, Mr. Peterson and his legal team filed a petition requesting a rehearing en banc before the full Fifth Circuit. Initially, the Department of Justice, still influenced at that time by officials carried over from the Biden administration, responded to that petition by maintaining the position that suppressors are not protected arms under the Second Amendment. However, that position changed significantly once the Trump administration, along with the Second Amendment Task Force and Pam Bondi, took a more active role in the case. In a newly submitted brief, the DOJ under the Trump administration stated that it is the view of the United States that the Second Amendment does protect firearm accessories and components, including suppressors. According to that brief, any restriction on the possession of suppressors places a burden on the constitutional right to bear arms. Therefore, an outright ban on suppressors, or similar firearm accessories, would be unconstitutional. The DOJ acknowledged that their earlier argument was incorrect and no longer reflected their current legal position. That said, the DOJ still contended that the registration and tax requirements imposed by the National Firearms Act are constitutional. They argued these requirements represent a modest burden and are consistent with the country's historical tradition, especially given that suppressors can be adapted for criminal misuse. For this reason, they supported the panel's original decision to affirm Mr. Peterson's conviction and argued that a full en banc rehearing was not necessary. Instead, the DOJ urged the Fifth Circuit to allow the same three-judge panel to rehear the case and reconsider their earlier analysis. According to their argument, the panel's legal reasoning, particularly regarding whether suppressors are protected under the Second Amendment, was flawed and should be corrected by that same panel. It now appears that this is precisely the course of action being taken. We've just received an official order from the Fifth Circuit stating that the original suppressor decision has been withdrawn. The notice confirmed that, by direction of the court, the prior opinion in the case has been pulled. This likely clears the way for the three-judge panel to re-examine the matter and issue a new ruling based on the updated legal arguments and the DOJ's revised position. Additionally, the court has now marked the petition for an en banc rehearing as moot, meaning it's no longer under consideration. This strongly indicates that the case will proceed under the review of the original three-judge panel alone, taking into account the DOJ's new stance and the broader constitutional implications raised in this challenge. There's another important development that adds a new layer to everything happening right now: the Hearing Protection Act. It was recently reintroduced as part of a larger legislative package and has already passed through the Senate. It went through the Senate parliamentarian for review, was approved, and then passed in a Senate vote. However, the current version of the Hearing Protection Act that made it through is not the complete reform many were hoping for. Instead of fully removing suppressors from the National Firearms Act, along with its registration and regulatory requirements, the version that passed only eliminates the $200 tax, reducing it to zero. That means all the other restrictions, including the registry and the application process, still remain in place. This limited change raises questions about how it might affect ongoing legal battles involving suppressors. There are several lawsuits currently in progress, including one that is already before the Supreme Court. These developments in Congress, paired with the legal challenges in the courts, could create significant changes in the way suppressors are regulated going forward. At this stage, there are a lot of moving parts. The DOJ has shifted its position, court rulings are being revisited, and now there's partial legislative action on the HPA. It's a critical time for suppressor policy and gun rights in general. As more updates come in, I'll be sure to keep you informed. Thank you for watching. If you found this video helpful or informative, please remember to like, leave a comment, and subscribe to the channel so you don't miss any future updates.